All right, so let's go ahead and get started. Dealing with common pitfalls. Now, our quote we're going to start with is from Jim Rohn. Life in all its uniqueness would not be life without the negatives and the positives. That is why it is important to be a serious student of both. Today we're going to be studying the negatives. Most of the time we don't do that. Most of the time we focus on what is it we need to do to build our business. Today is going to be what do we need to do to safeguard our business, to protect us from losing it all in a legal complaint or something like that. I'm going to start out with implied agency, but before we go here, I want to take you guys to the internet, and what we're looking at here is a page out of, you'll look at the top, I don't know if you see that, realestate.utah.gov. The Division of Real Estate in Utah sends out what I call our quarterly walk of shame. It's a newsletter. It's got updates on the laws, legal things, all of that. But then they also talk about licensing and disciplinary actions. All right. So I just got a warning that the computer audio may not be working very well. If that's the case, please let me know. In fact, let's do a quick audio check. If you can hear me, will you click the webinar dashboard button and raise your hand? Okay, it seems to be working fine. I'm not sure why that alert went off. I'll go ahead and lower those hands. Anyways, once a quarter, we get a list of licensing and disciplinary actions. Most of them are pretty mundane. It's things like people have applied for a real estate license that had a past criminal history that they failed to disclose, something like that. But I wanted to share one with you here. It cost the guy $5,000 and 7 hours of additional CE. Okay, and what happened? He was a principal broker. So this can happen to anybody. The best of the best. We've seen some of our agents in here. Some of our brokers have been here. We all make mistakes from time to time. I really hope I don't show up in here someday, but I could because of one moment of just being a little bit relaxed. And so I applaud you guys for taking the time out of your busy schedules to come here and remind yourself that there is a serious side to this. Well, most of the business is serious. There's some fun things, there's some drudgery, but there's also a very hard line that we can't cross, and a lot of people do. Not everybody gets caught. Very few people do, actually. But when you do get caught, it can be life-changing. In this case, the principal broker failed to inform his sales agents that his license had expired. Now, when his license expires, it affects all of their licenses. He didn't disclose a pending investigation, and he acted as a principal broker when he was not licensed to do so because, obviously, his license had expired. So $5,000 penalty, 7 hours of continuing CE. Later on, we'll see another agent who also acted without an active license, and it only cost her $1,000, probably because it wasn't a principal broker that had other agents depending on her. However, there are real issues with this. So let's jump back to our pitfalls. I'm going to be providing to you real examples, and it is public record, by the way, using people's real names. And I'm only doing that because it is public record. I'm not trying to shame anybody. If anybody on here sees themselves or a name of somebody they know, like I said, it happens, and we're going to use it here as a lesson to try to help everybody, okay? Try to learn from other people's mistakes so we don't have to make them all ourselves. Agency by implication is defined as when an agent acts in the role of an agent, whether a contract for agency exists or not. In such an occasion, the agent may also have full liability in the transaction. I get questions like this every single week from my agents, all right? I just had one a couple of days ago. Somebody said, hey, I've got somebody, they're a friend of mine, I just need to help them out with some paperwork. What does it cost to do that? I mean, they've already got the buyer there, they just need some help with the paperwork. Well, you have full liability. That means as a company, we have full liability. So in that situation where you're just helping out a friend, we have to charge the full transaction fee, the $4.99 transaction fee and the $60, whatever we call that, compliance fee is what I've always called it. So we got to collect $559 because our liability is the same for that as it is for a $300,000 client that you've got an exclusive right to sell agreement and all the paperwork and everything. In other words, you should treat that favor as it would be any other client, because once you're in an inch, you're in a mile. That's how the division of real estate looks at it. If you're helping somebody in any way, shape, or form, you've created agency by implication, even when a contract for agency does not exist. In other words, you have full liability, even if you're just doing it as a favor. Now, I'm going to give you a quick example here, and it seems harsh. I'm going to be real blunt with you. Some of you might judge me poorly because of this. My parents, who I love very much, I'm close to them. I don't have bitter feelings at all, and they don't have any towards me. But when they retired from Las Vegas and wanted to move back to Utah, they called me up, and they had been online like everybody has. They'd been online, they'd been looking at homes, they'd seen some for sale by owners, and they called me up and they said, probably out of some sense of maternal duty, hey son, we'd like for you to represent us. So I've been training on this for a long time, and I've actually followed my training, and I sat down with them and I gave them my full buyer's presentation so they could truly appreciate everything I was going to do for them. And it raised a concern that was a good concern, and I'm glad we talked about it. They said, well, we do have several for sale by owners that we've talked to, and they've told us they would not like to deal with an agent. And so in those cases, will you step out and we'll just deal with those on our own? And then if it's a case where there is an agent, then you can come on board and help us. And I tried to talk to them and help educate them a little bit, but they're my parents and I'm their kid. And I don't think they listened very well about some of the dangers of working on your own with a for sale by owner who also doesn't know what they're doing. And of course, if you've been in the business long, you realize it doesn't matter at all that they have prior experience in buying and selling homes. This business can get nasty pretty quickly. So I informed them that no, I cannot help them in some cases and then bow out in other cases, because if I'm acting as their agent in some cases, I have agency. And if they're doing a for sale by owner and they just say, well, Eric, what do you think about this? Well, I've been helping them on other things. And let's say that for sale by owner goes south, which odds are very high that it will, with two people that don't know what they're doing and don't know how to prepare paperwork and don't have accurate paperwork. Odds are pretty high that there's going to be some problems there. So let's say that goes to court and they said, well, our agent told us this. And that's exactly what's happened in the past. And I've seen people charged, again, on that quarterly walk of shame. I've seen people charged, and their excuse was, it was just a friend I was helping out. I didn't have agency with them. And yet they were still issued a fine and a penalty. And so with my mom, again, who I love very much, when she said, this is the way we want to do it, I said, I can't work under those conditions. It's either all or nothing for me. Because in the eyes of the law, that's what it is. And she said, well, we don't want to miss out on a couple of these, and so we're going to go with nothing. And I had a couple of my siblings call me up and they say, are you serious? This is mom and dad we're talking about. And I said, yes, I'm very serious, because as much as I love mom and dad, I have a wife and children that I'm responsible for. That's who I've made a commitment to firsthand to provide for. And I put my ability to earn a living at risk when I do these favors for people. And I had an agent call me last week, and she said, my best friend just wanted me to help her with paperwork. And I told her I couldn't do that, but I just wanted to confirm. And I said, good for you. You can't do that. Why would your best friend ask you to compromise your ability to earn a living? That's not a best friend. Now, my parents respected my decision. My siblings, most of which I've gotten into real estate over the years, have learned, hopefully, to understand why I did that. But none of them jumped in to help either. So regardless, agency by implication is a big deal. And it happens to the best of us. It happens very innocently, where we're simply helping out a friend or a family member by providing forms, maybe giving a little bit of advice here and there. right? Because everybody likes to feel valued. And so people call us and they ask us a little bit of advice. My response is always, you know what? I would love to help you. Sounds like this situation could get very sticky. Here's the law. Here's how it works for me. If I help you at all, I have to help you all the way. I'm going to have to get involved. I'm going to have to make sure all your paperwork is done correctly. And of course, that's a good thing for you. But I'm going to be with you for the rest of the transaction right up till close, because I can't just give little bits of advice and not have full liability. So if I'm going to have full liability no matter what I do, then I'm going to be involved fully. And this is what I charge for that. Now, the nice thing is with equity is that you can negotiate whatever you want. So a lot of times I'll do that for a flat $1,000 because they've already got the buyer and I'm just stepping in. If it's a really messy situation, then I might charge more. That is completely up to you on what you do, but realize that as a company, we've got full liability, so we have to charge that full fee. All right. Another way that this comes up very innocently is we start without an agency agreement signed. And so many agents are guilty of this, and they have so many excuses that I poke lots of holes in when we talk about working with buyers. So we've got a separate training where we talk about working with buyers. If you haven't seen that, you need to watch it, because agents are guilty of this all the time. And it comes up because people call off of one of our ads or off of one of our listings, and they say, hey, I saw this home and I'd like to go see it. And we say, fantastic. So we can show them that home, and then we say, you know, there's actually 3 or 4 more in this neighborhood that I can show you because we're trying to become more valuable to them so that they'll hire us, right? So we start showing them homes. And I don't know, agents have told me they feel like they need a test run so that people can commit to them. And again, if you watch the buyer training, we kind of debunk that myth. Anyways, it happens a lot. We're showing people homes. Inevitably, as we're showing them homes, we start giving them advice. We're talking about things, forms, paperwork, how to do things, and we're creating agency simply by our actions. So one way to avoid this, obviously, if I've got a listing that somebody calls on, I've got a fiduciary duty to the seller. I have to show that listing. If I'm going to show any other listings, then I have to draw a hard line. And so I'll call people up and I'll say, great, I've got that home, love to show it to you. If you'd like to see 3 or 4 others, I can show you those as well. So we'll meet at my listing, I'll show them that home, and I'd say, you know what, if you'd like to see these others, then I'm happy to show these to you. I've got showings scheduled for you. Here's the deal. In this regard, I would be acting as a buyer's agent. Now, I know you don't know me. I can take 5 minutes and show you really quickly what I do. And by the way, if you've watched my buyer training, I have a little 1-page script for this, kind of your elevator script for buyer's agents. And so I have that 1 page with me. I give it to them. You know, here's what I do for my buyer clients. And if you'd like to hire me as your agent, then that's great. Otherwise, we can sign an agency agreement just for these next 4 listings that I'm about to show you. And sometimes people will sign it outright, you know, with the little 5-minute script, like, you know what, this looks great, we'll just use you. And they'll use me for all of them. Other people have said, you know what, I guess that's fair. You know, if we end up buying one of these homes that you're showing us today, then we'll use you. Other people have said, no, we're not going to have an agent. We're going to do this all on our own. And if that happens, then I say, well, then I'm sorry, I can't show you these other homes. And the response is always the same. It's, are you serious? You're the only agent that has demanded agency. And I said, well, I am one of the best in this market, so I'm not too surprised by that. But I don't break the law, and I don't put my livelihood at jeopardy. So if you'd like to see these homes with one of the best agents, I'm happy to work with you. But if they don't, guys, walk away. You got to realize that somebody that would, number one, want you to put your license at risk, once you explain to them kind of how it works, and they want you to put your license at risk to do them a favor, and they're a stranger, by the way, you don't know them, you're hoping to get their business, that's a little crazy. But on a whole different level, even if that part doesn't factor in, there's a sense of fairness that is pretty basic. If you show me this home, sure, I'll work with you. That's a pretty basic sense of fairness. And I can make an exclusive buyer-broker agreement specific to one particular MLS thing. I've got somebody that's typed in, is that an NAR policy or a state-based policy? That's something that, and by the way, NAR is the National Association of Realtors, which is, we're talking code of ethics, not law. And here I'm talking law, so NAR wouldn't come into it. So is there this concept of agency by implication in every state? I believe the answer is yes. If you're not certain, then by all means talk to your broker and say, do we have agency by implication in our state? If so, how does it work? Okay, but that's my rule. And I have had people, not very often, but I have had people that really don't give a crap about my requirements under the law. They don't give a crap about any sense of fairness, and I run from those people. I don't care if there's a potential commission being lost, because those are the types of people that will commit loan fraud. I mean, they don't care about any but themselves, and that's scary, okay? They'll do all sorts of things. They'll be your biggest nightmare clients, and I simply don't work with them, all right? Another situation that comes up, and this is state specific, okay? And there's about a third of the states in the union, 14 or 15 I believe it is, that have conflicts with this. And that is assisting a seller with paperwork in an MLS entry only or a fee for service situation. Okay, what this is, let me see if I've got a slide on this on the next page. Not yet. Let me talk about this really quick. I know I've got other issues or slides that do talk about it a little bit. Okay, in certain states, Utah being one of them, we actually have a law in the books that says there's a minimum level of service that a listing agent needs to perform for their clients. All right, they need to provide paperwork, they need to assist with negotiations, and they need to be with them through the final process, reviewing the closing documents, etc. Okay, so pretty simple criteria. However, there are companies in the free market that do a MLS entry only fee or a fee for service situation. In other words, I'll pay you $500, Mr. Agent. Let's call him Agent Smith. I'll pay Agent Smith $500 if they'll just put my home on the MLS. I don't want them to represent me. I don't want them to provide me paperwork. I don't want them to do anything else, regardless of whether the law requires it or not. I only want to pay for the marketing to get it on the MLS. So Agent Smith charges me $500. He posts it on the MLS. He doesn't care if it sells or not. He's got his money. So he's on to the next one, and that's their business model. And even though it's not legal, it's allowed. And this is odd because why would something illegal still be allowed? Well, it's because the Department of Justice, which is federal and carries the biggest stick in town, wrote a letter to all of the states. And I actually got a copy of the letter from them when I called frustrated with some of these. I spent a good long time on the phone with an attorney for, I believe it's the MLS attorney, and he said they can't enforce it. They can't enforce their own law because the Department of Justice has written them saying you are inhibiting free trade. If somebody comes up with a different business model, then you have to allow them. And our argument back is, well, we're protecting the sellers. There's a minimum level of service that they need done to protect them. And the DOJ's response was proof that they're being harmed. You know, how are you protecting them if you can't prove that they're being harmed? And it's hard to prove that a seller's being harmed because most of the times they don't know they've been taken advantage of because they don't understand the paperwork. So anyways, there are a lot of states that have laws against maybe a fee-for-service thing, but they're hindered in whether they do it. The other states, it's just open. You can do fee-for-service. You can do whatever. The problem that this creates is for the buyer's agents, because we come into the picture and here's a seller that doesn't have the correct paperwork, and we start providing them with forms and paperwork and helping them fill out the paperwork correctly, and sure enough, we're creating agency by implication. Now, Utah last year, to counter this, we actually created a law that said, specifically for this situation that I've outlined, buyer's agents helping a seller in this regard do not create agency by implication. If your state does not have a law like that that protects you, then one of the things that you can do, and I'll cover this a little bit later, but I'll just hint at it now. One of the things that you can do, and I'll still do it regardless of whether the law is there or not, if I'm working with a fee-for-service seller like that, I'll have them sign a for sale by owner commission agreement that states clearly in there, if I'm working with you, then I don't have liability when I provide paperwork or forms or advice, because it's in my buyer's best interest to make sure that this job is done correctly. And I'm helping you only to that extent of making sure that the job is done correctly for my buyer's benefit, and that in no way creates an agency by implication model. All right, let's see some of the penalties. $10,000 here for Miss Wiley. She failed to execute written agency agreements, failed to obtain written informed consent required to represent both parties. So she's got limited agency here, and was utilizing outdated listing agreements. So not using updated forms, failed to execute fully written agreements, agency agreements. So she's basically working without agency. $10,000 and 20 hours of CE. Mr. Barker, principal broker, $20,000 fine. Failed to exercise active supervision over a license with him, failed to maintain and safeguard documents, and failed to obtain informed written consent in order to represent both principals in a transaction as a limited agent. So these guys are all working on agency by implication. Basically, they're representing people without the paperwork signed. So be very careful about this. Some of the penalties can be pretty stiff. Written agency, sales agent, stipulated order on January 19th. Ms. Fry violated Utah law by assisting a buyer with the purchase of a property without first obtaining the required written agency, and she made up her own form. She wasn't familiar with the forms in her toolbox, which is the forms that your State Association of Realtors in Utah, the UAR, creates these forms for us. So civil penalty of $1,000. It's a crappy way to spend your money. So always sign an agency agreement up front, especially with friends and family. Okay, don't cheat your friends and family. We've talked about this in working with buyers and in working with sellers. Friends and family are important. They're your biggest source of referrals. Give them your highest level of service. That means whether they need a full presentation to hire you or not, sit down and give them the full presentation. Let them know how you're a rock star listing agent, how you're a rock star buyer's agent. Give them the full presentation. Get them to sign an agency agreement with you up front. When dealing with a fee-for-service agent, make sure you have a form signed by the seller disclosing agency, so you could use a for sale by owner commission agreement, something like that. And if you're going to be interacting with somebody else's client, because technically they are a client of the other person, this fee-for-service broker, then ask that broker for permission. Just save an email as permission that you can interact directly with that client, okay? And that will protect you against any claims that are coming up later on. All right, let's talk limited agency, because that was some of the issues that we saw there. Limited agency is where you're representing both parties, and in some states that's legal, in others it isn't. In Utah, it is legal. You represent the buyer and the seller on the same transaction. In this case, she failed to have, having failed to provide her client with a limited agency acknowledgement prior to submitting an offer on a property listed with another agent from her brokerage. Now, this brings up an important concept, which is getting bigger for us as we grow bigger. If I make an offer to another agent in my brokerage, then it's limited agency because we're both under the same broker. Even though I'm not representing both seller and buyer personally, I'm representing one and somebody else from my brokerage is representing one. However, in Utah and in some of the states where we're getting bigger, Colorado, California, we're growing quite a bit. Let's say that I write an offer for somebody in Troy's office, okay, or Steve's office. Well, now we're two different branch brokers, but we're all under the same principal broker, which is me. I'm the principal broker for the state of Utah. So limited agency still applies. Even though we're not in the same office, we're not even in the same county maybe. That doesn't matter. Even if it's somebody all the way down in St. George in Nancy's office, we're all under the same principal broker in Utah, and we have to use the limited agency form. So be aware of that if you're in a state where equity is growing a little bit. And again, talk to your broker and see if you have this limited agency concept. And if so, how does it apply to you? But that's how it applies to the folks in Utah, is an offer with any brokerage within the state. We're all under the same principal broker, so limited agency applies. And you do have to have those forms or you can get a decent fine. All right, our pitfall number 2 is mishandling earnest money. Now, anytime you mishandle other people's money, it's one of the quickest ways to lose your licenses. People that do big financial, like Ponzi schemes and stuff like that, they frequently get more jail time than people that commit murder do. We take this kind of stuff pretty serious with our legal system. So let's talk about how to handle earnest money. Number 1, when do we collect the earnest money? The answer is very simple. What does your contract say? All right. In Utah, our contract has 2 options. We can either collect it with the offer itself, or we can collect it within 4 days of acceptance. What happens if we can't do that? What if we check the box that says we're going to collect it within 4 days, and our client goes out of town and we can't get it from them? Well, we have an affirmative duty. That means that we have to take the initiative here and alert the other party that we couldn't perform on that. Now, that makes our contract voidable, not necessarily void, but it does say that we failed to perform on that part of the contract. So if the other party wanted to cancel, they could. We've weakened our position there. If the other party says, oh, you know what, it's okay, when they get back, get it in and just let us know. If we do that, and we move on, then the contract is not void and we've passed that risk up. But otherwise, don't create weaknesses in your contracts. Collect the earnest money when you say you're going to collect it. Step number 2, where do we deposit it? Well, again, the answer is very simple. What does the contract say? Now, our practice here in Utah, at least, is we're going to hold the earnest money with the title company. I don't know what other states' practices are, so we're going to hold the earnest money with the title company 99 times out of 100. We could hold it in our trust accounts if we had to, but there's certain delays that happen with that that aren't ideal for us, so we're going to hold it at the title company. So that's why in Utah it's required on all our paperwork, if we're holding it with the title company, that we disclose that, because the contract is written and says that we're going to hold it with the brokerage trust account. And if that's not happening, then we need to spell out in an addendum what is happening. We're going to hold this money with XYZ title company in accordance with state law. All right, so we have that language written in. We have it on our checklist so that you can remember. We have it actually written into some of our forms on .loop, on an addendum. So we've got lots of reminders that this is how we do it. This is another reminder for you. Now, how do I do this? Because I talked with our state attorney that we use here, and he loves this idea. I don't like to handle the earnest money at all. So I have, as part of my standard practice, a checklist. One of the items on my checklist for a buyer is as soon as we go under contract, then we email that buyer, say, congratulations, we're under contract. We have to deliver $1,000 earnest money to XYZ title company within 4 days. So by this day is when it needs to be turned in. Here's the addresses of the title company. Let us know which one you plan to drop this off and when, and we'll alert them to be expecting it. So I actually have my clients, because we've got title companies all up and down the Wasatch Front. It's much easier for my clients to get there than the one office location that I've got. So I actually don't collect it at all. On their way to work, on their way to school, whatever it is they're doing, on their way to the grocery store, they can drop off the earnest money very easily. It's convenient for them. And I give my escrow officer a call in advance, and I say, hey, they're going to be dropping the money off at the Kaysville location. let your guys there know. And so she calls them. When the money's dropped off, they alert her. She has saved on her computer my earnest money receipt form. So she fills that out and sends it over to me, and we're done. We've collected the earnest money as required by the contract. I've got the receipt form signed by the party that actually received it. I don't ever sign receipt. And occasionally I'll have the other agent call me and say, hey, you need to sign the purchase contract saying that you've received the money. And I say, no, I don't, because I never received the money. I don't ever sign and say that I've received something when I haven't done so. So what I will send you is the receipt signed by the title company, which is what we have in the contract. And they say, I'm not sure that'll work. I said, talk to your broker. It'll work just fine. And they do, and it does. And we all move on happily ever after. And it's been more convenient for my client and certainly more convenient for me. All right, we've got another quick question here. All right, I'm not sure what state you're in, Renee, but here's the question. Isn't the earnest money given to the listing broker in Pennsylvania? You'll have to talk to your Pennsylvania broker about this. Isn't the earnest money given to the listing broker when we are representing a buyer? In Utah, absolutely not. We don't give our earnest money to the other brokerage. We would either hold it in our trust account if we're working with the buyer, or like I said, the way we do it 9 times out of 10 is we have it held by the title company. So talk to your broker and make sure how you do it out there, but that's how we do it, and I know it's corporate policy if we can anywhere. So somebody said, do you fill out the earnest money field on the purchase contract? Well, yeah, I state that we're going to collect $1,000 earnest money, and it's going to be in the form of a check delivered to whatever title company, but I don't sign for receipt underneath that because I haven't received it. So never sign for something that didn't actually happen, all right? I hope that answered your question, Renee, on that. So talk to your broker, make sure you're handling earnest money correctly for your state. The other one that happens is, what if it bounces? What if I get a call from the title company and they say, hey, we went to deposit this check and insufficient funds, it did not clear. Again, I have an affirmative obligation. I'm going to call my client first. I'm going to say, hey, our check bounced. I have to notify the other party. And they say, oh, man, we just barely got paid. We'll get the money in there. We'll get a new check written. So I have to call the other party and immediately tell them our check bounced. We've already got a plan in place, and we'll get it taken care of. The only time I wouldn't have to make that call is if I was still well within my deadline. So if my client says, you know what, I'll get it taken care of right away, and that was on day 1, and I've got 4 days to get it turned in, then on day 2 or day 3, I'll check with my title company and see if the check cleared, the new one did. And if it cleared, I'm fine. I don't have to tell the other party. But if I'm past my deadline and my earnest money hasn't cleared, I've got an affirmative obligation to call the other broker and say, hey, this check didn't clear. We do have a plan, but again, I've put the contract at risk and made it voidable for my clients, or they have, because their earnest money check didn't clear. All right, hopefully that is clear for everybody. If what I've told you is different for your state, again, just use it as a dialogue with your broker, which is always a good thing. All right. All right, operating with an expired license. I've already shown you a couple real-life examples of where this costs people money from our very latest newsletter. The solution is very simple. Know how to check the expiration date on your license and stay current on your CE classes. All right, how do you check the expiration date? You simply go to your, sorry, I'm keeping an eye on our comments here. Okay, we've got another comment from Pennsylvania that says, in Pennsylvania, we give our earnest money to the listing brokerage. That is interesting. I do appreciate you telling me that, because it helps me understand some other states. So some different rules out there. Let's see here. I think that's all of them. All right, so first of all, know how in your state to manage your license. Know where to check to see if it's current. In Utah, we do everything online. So you have to log into the real estate website. We call it RELMS, Real Estate License Management System. If you've never done it, go do it. In whatever state you're in, make sure you know when your license expires. As brokers, we also alert all of our agents, but inevitably, I'll have 3 or 4 agents that we're 15 days from the end of the month and they're still not renewed. And the problem with that is they've got CE classes that haven't been maintained up to date. Now, first of all, this gets expensive because when you're buying CE credits online, they charge you for it, and it can get pricey pretty quick. If you stay current, I mean, the local board offices offer CE. I bring in CE to my office almost every week. If you're staying involved, then you've got plenty of opportunities to get all of your CE credits in. So stay involved with that. Next, be aware that if you're cramming your CE classes into at the last day, that they have to be reported to the Division of Real Estate in order for them to count. And the division has said if it's not done within 2 weeks, we reserve 2 weeks to get it done. Sometimes they'll get it done quicker than that, but that means if you got it done on the last day, your license could actually lapse for 14 days. Now, understand from a broker's perspective, if your license lapses, we can't pay you. So if you have pending commissions, we can't cut a check. We can hold on to the funds for a while and let you get your license renewed and then pay you. We're not going to confiscate your money, but we can't issue you commission checks, and I have to take away all of your clients. So if you're working with sellers, I have to inactivate your listings or move them over to another agent. You can't have active sellers. You can't go out and show homes with buyers. You have to cease and desist all your activities as an agent, which is, number one, humiliating if you have to go to your clients and say, my license lapsed, and you're going to be under another agent for a while. That's really weird. So just stay on top of this. I've got another comment here that I want to read through really quick. So let me expand this out here. All right, the process is so different from Pennsylvania way of doing business. There will need to be some additional training, and companies that will carry an escrow account. Our title companies do not usually hold the money in any way. It's the listing broker who holds escrow. Okay, so again, for Pennsylvania, it looks like I'm getting the same story for everybody. Just talk with your brokers and make sure. I know that there's different ways of doing things. I know I can't address all of these pitfalls that are so different in every state. I'm aware of those shortcomings, but I want to provide the training so that even if I can't address the pitfalls for your state specifically, that I at least raise the issue so that you're aware of it, so that you can have a discussion with your broker. So again, I apologize for some of the different specifics, but the intent is the same. Make sure that you're aware of the rules in your state and make sure that you do it correctly, because if you do break the rules, the penalties can be kind of severe. All right, to wrap up today, we're going to talk about a bunch of different money problems. All right, first of all, working with builders. Most of the time, working with builders is great. Builders know that realtors can be their best friend, and most of them treat us pretty well. There are a few out there that don't play by those same rules, however. Okay, so I've got beware of builders in sheep's clothing. Here's the problem: a lot of agents don't understand how we get paid our buyer agent commission when we're the buyer or when we're representing the buyer. We get paid, for example, if it's an MLS listing, then on the MLS listing, we've got an agreement to be a part of the MLS that says that if we offer a buyer agent commission on there, then we have to pay that commission. And if for some reason a brokerage failed to pay that commission, then their entire brokerage would get kicked off the MLS, subsequently and effectively shutting them down. So if you broadcast it over the MLS that you're going to pay a 3% buyer agent commission, then you're pretty well protected that it's going to be paid. However, the problem arises when we're working with builders, or and sometimes when we're working with different MLSs that aren't the same one as us, that we don't have any commission agreement there. Now, I know in other states, again, like Colorado, there's a whole bunch of different MLSs. In Utah, we're lucky that we've got, like, I think 3 different MLS systems for the whole state. But in Colorado, you'll have a lot more than that in one city. Okay? It's a totally different ballgame. So some of you are very well prepared for this, and it's a standard matter of practice for you that you get a commission agreement signed on all your stuff. In Utah and some other places, beware that just because a builder advertises a home doesn't mean you're guaranteed a commission on it. So if I'm working with a builder, and I had one, I'll give you a real life example. I sat down with the builder, and their model home was on the MLS, but all of the other homes in the subdivision weren't. So I had no guarantee of commission. So we're filling out the paperwork, and I noticed they didn't have a commission agreement form, which most builders do. And I said, hey, I'm going to need a commission agreement form from you. And he turns to page 2 of our purchase contract and says, oh, right here, we've got you as representing the buyers. We know you're representing them. I said, that's all fine and dandy, but it doesn't say that you're going to pay me for that. And the truth is, we have agents that have gone through the entire process, represented their client very well, and not been paid a commission at the end because they just assumed they would get paid. If there's not something in writing saying you're going to get paid, you're not going to get paid. And that comes as a horrible shock to somebody when they've just worked for 5 or 6 months and they don't get anything. So how do we protect ourselves from this? If you're working with a builder, get an agency agreement signed. If you're working with a listing that's not in your MLS, then get an agency agreement signed by that brokerage so that you get your commission. We do have something in writing if you're working inside the same MLS, and that's actually in writing per the terms of belonging to that MLS. So it's not something that you're getting every single time, but just be aware that if a builder says, oh, don't worry, we know you're being represented, or that you're representing the buyers, then worry, okay? This isn't the business of taking people's word. If it worked that way, then when we're negotiating for the fridge, and they say, don't worry, we'll give you the fridge, we say, oh, great, we don't need to write anything in the contract then. Of course, that would be silly. But yet when it comes to our commission, sometimes we're buffaloed and are tricked a little bit there, okay? Next, when in doubt, write it out. And this applies to almost everything. I have agents call me and say, what should I do in this situation? And it's kind of a weird, unique deal. I just said, spell it out. You know, I just had a house sell. It was a bigger house, about 6,000 square feet. It was going to take the sellers a long time to move. And they had been burned before. They didn't want to sell the home and then have it fall apart the day before closing. And so they said, we want 7 days to move. Well, it's very simple. We specify that very clearly. You know, sellers to turn over possession within 7 days of settlement. If there's ever a question, write it out in detail. How are you going to get paid? If there's a question, write it out. Put it in the contract, okay? This next one, 3% buyer agent commission versus commission to be split 50-50. Who wins? I'm going to show you the next slide here. This is actually one of our agents, a good agent. And on a short sale, quite often in the agent remarks, they'll say something like this. This is a short sale. If seller's lender, as a condition of approving the sale, requires a reduction in the total commission agreed to by seller in the listing agreement, any such reduction shall be divided 50-50 between seller and the buyer's broker. All right? Pretty standard language. It's boilerplate. A lot of people use it. It doesn't work legally. All right? In the words, and they're cheesy, but these are the direct words from the MLS attorney. He said, what the BAC giveth, the remarks cannot taketh away. All right? Like I said, it was cheesy. But if my BAC says 3% and somebody tries to give me 2.5% later on because they say that the lender didn't pay them a full 6, that's their problem, not mine. So if you're a short sale agent listing stuff, then you could type in here 2.5% to 3%, because then you've padded it for yourself. There is a chance that you may not get paid that full amount. Oops, what did I do here? So you have to change it in the buyer agent commission. You have to specify 2.5 to 3%. All right, so that's that one. Who wins? Whatever you say is the BAC is the BAC, and you have to pay that. All right. What's the problem with getting paid directly by a client? So let's say that I'm working with a client, and this, again, came up just last week with one of my agents. All of these are very, very common. Let's say that I'm working with a client, and it could be any number of scenarios, but in this scenario, I'm going to choose the home did not sell, okay? But I worked hard on it. They know I worked hard. They're impressed with me. I did a great job, but the home did not sell, and they say, you know what? We want to treat you right. We don't feel like it's fair that you walk away with nothing because it's not your fault this didn't sell. Those buyers were crazy. They walked away, whatever. We want to give you $1,000 for your time. Can I take it? The answer is yes, but it has to be in a specific way. Number one, they can't write me a check directly, ever. Okay, I have to get paid through my brokerage. So they have to write the check to Equity Real Estate. And this isn't company policy, this is state law. So they're going to have to write a check to the brokerage, and the brokerage is going to take out a small fee. They're not going to take out the full $4.99 transaction fee because there's no transaction here that they have to manage. However, they do have to cover some payroll costs. So they're going to take out a $150 processing fee, and I'll get the remaining $850 to keep for myself. So I can get paid directly by a client for services if the money goes through the brokerage, and then understand that we have a few costs of payroll just for processing it that we're going to take a small chunk for, okay? All right, the next one is referral fees. How much is too much? Does the form matter? Let's talk about referral fees to other agents. Industry standard is 25%. You can negotiate whatever you want. Quite often I'll get 30%. There's times I've negotiated for my agents and gotten a 50% referral fee in working with another agent, okay? So you can negotiate whatever you want in working with an agent. What about if it's a referral from a client? So John Smith, one of my longtime clients, refers me to his sister, Nancy Smith. And he tells Nancy, you need to call Eric Lee. He's an amazing agent. He'll do a great job for you. And so Nancy calls me up and says, my good friend, or my brother John, said that you do a great job and we'd like you to list our house. What can I do for John to take care of him for sending me a referral? Now this will be specific state by state, so again, open up a dialogue with your broker and find out exactly what the rule is for your state. In Utah, we can give a gift valued up to $150 for a referral, all right? Now I highly recommend, when I say does the form of the gift matter, I believe yes. I don't want to give cash, because there is a different law talking about illegal sharing of commissions. In other words, I can't pay my commissions to an unlicensed individual or give them a portion of it because they're unlicensed. So if I wait for this deal to close when I've got the cash, and then I go to John and say, John, here's $150 cash, thank you for the referral, I could be within my legal rights by giving them the gift, but I could be breaking the law because I've illegally shared my commission with John. So what I'm going to do is I'm going to avoid the whole cash thing. I'm going to give him a gift card. I'm going to give him a nice gift. I'm going to give him something that says, John, I really appreciate you for doing this. But whatever that something is, it's not going to be cash. So it's not directly tied to the closing. It's just tied to the gift. Does that make sense? Or tied to the referral? By the way, you cannot market this, at least in Utah. It has to be an unsolicited gift, which is, by the way, I think the stupidest law in the books. If I can legally give my client a gift for a referral, then why can't I solicit that? Why can't I advertise or promote that? But you can't. And we had a lot of people. First of the year, Facebook was blowing up with people saying, hey, refer me and I'll give you this much. And what they could do was legal. They just couldn't say it. Okay, it has to be unsolicited. So the minute you put it out there and start soliciting referrals, you've broken the law again. So some weird stuff out there on the books. Make sure you know what the rules are in your state. Next, what if I wouldn't want to give my client a gift? Okay, so Nancy Smith is a dream client. She's, let's say she's buying a home, and so we go through, and I want to give her a really nice gift. I mean, something really nice. I'm going to give her a $600, $700 gift, okay? Can I do that? It's well over the $150 referral limit, but remember now I'm talking about something completely different. I'm talking about giving my client a gift. And realtors have been doing this for years. They screw up on the contract, and they forget to mention that the refrigerator is included in the sale, even though the clients told them to do that. And they realize they made the mistake, and so they buy their clients a fridge. That's a closing gift. Okay, is it legal to do that? The answer is yes. But again, there's some rules that need to be followed in order to make that gift legal. Now, in Utah, we have a gift letter, and we've actually gotten the law copied and pasted into that gift letter, and it says 3 criteria have to be met. Number 1, your principal broker has to be aware and okay with the gift, which if you're using the gift letter and it's turned in with your packet, then you've met with that obligation. Number 2, the lender has to be okay with the gift. So again, no cash, because there's no lender out there that's going to be okay with you saying, I'm going to give my clients $500 cash at the end of this transaction. Okay? No underwriter ever will allow you to do that. So, can I give my clients a $500 TV? Sure, they don't care about that, but you can't give them cash. And run that by your lender if you're not sure, but I don't know any lenders that are going to allow you to give your client cash after closing. At least buyers anyway, sellers, they don't care. Okay, so the lender has to know about it and be okay with it. And then lastly, the party paying the commission. So again, if I'm working with the buyer, the seller or the listing brokerage is paying my commission. So I have to let them know. And I do that, again, by simply sending them a copy of this form. So, all right, I've got an older question here I need to address. It took a little while to type out, but this is going back to that short sale commission. So let me read it. In your statement about the short sale commission being subject to bank approval, if the commission is 6%, 3% to listing agent, 3% to a buyer's agent, who pays the 0.5% if the bank only offers a 5% split, 50-50 between agents? If you haven't made any other comments, then that comes, and it's not a 0.5%. If you advertise a 3% buyer agent commission and the bank only paid 5%, that means the listing agent would only get 2%. Okay? Now, most of the time, a buyer's agent takes their 2.5 and goes their way. But if they raise a stink about it, then legally they can enforce that 3% buyer agent commission that you advertised. That means you would take a full 1% loss and only make 2% for that. So again, if you are advertising as a short sale agent, then specify in your buyer agent commission that it's going to be 2.5 to 3% commission. And then you'd get 2.5 and the other agent would get 2.5 if the bank decided to shortchange you and only pay 5%. Hopefully that answered that question on there, okay? All right, so that covers all the money problems here. Using the gift letter, if you're giving your client a gift in any form, and a lot of people, they give their client, you know, let's see, I saw somebody, a different agent, I was waiting for a closing the other day at the title company, and somebody came in and they had a welcome floor mat, okay? What about that gift? Well, the law doesn't specify if the gift is valued over a certain amount that you have to use this gift letter, or that you have to comply with these rules. The law is just simply, if you're giving your client a gift, then you have to comply with these rules. So even if it's a very simple gift, technically you should be using the gift letter. And again, very few people do that, but I don't want to be the guy that discovers that I'm breaking the law and getting in trouble for it. All right, really quickly, let's talk about advertising. In this case, Mr. Booth got charged with a $500 civil penalty for advertising the sale of a property without having the brokerage name on the sign. Let's talk about where you need your brokerage name when you're marketing. Everywhere, okay? You've got to have it on your website. And it doesn't matter that you are the Mr. Booth team, okay? Let's say that that is the name of your team, Mr. Booth team. And so you've got a website that has Mr. Booth team really big at the top of it. Way down at the bottom it says equity real estate. That's fine, okay? In Utah, the law is that the brokerage name has to be 50% the size of your largest print. So if Mr. Booth team is huge at the top, half of that size needs to be equity real estate down at the bottom. It needs to be on your signs, it needs to be on your flyers, it needs to be on your business cards, it needs to be on, if you buy a truck and wrap a truck, it's got to be on there, it's got to be on your billboards. Whatever you're going to do You need to have truth in advertising, basically. You're not, Mr. Booth is not his own company. He needs to stipulate that he's licensed with a brokerage. Okay? Guys, thank you for taking your time. We're about a minute short of our hour. I know that this is probably training because everything I cover varies from state to state. I've tried to bring up common concerns, and again, I appreciate the folks from Pennsylvania who informed me that rules there are a little bit different, and that's great. If your rules are different, that's fine. Just make sure you know what those rules are. Again, thanks for joining me, and we will see you all online next week, hopefully. And again, if you've got questions or you'd like to revisit this, go and subscribe to my YouTube channel. Thanks, you guys, and have a great week.